Welcome to our 5th episode of the Settling Disputes in Construction Industry, a practical guide to mediation by AIADR. The episode today will be slightly different as we will be having a discussion with Ms. Samrith Kaur and Ms. Revathi Kannan on their insight and experience in the mediation field. Ms. Samrith is an advocate and solicitor and managing partner at Messrs. Samrith Sanjiv Partners. She is a fellow of the Chartered Institute of Arbitrators, United Kingdom, and with the Malaysian Institute of Arbitrators. She was past vice chairman of the Chartered Institute of Arbitrators, Kuala Lumpur Branch, and currently the president of Sports Law Association Malaysia, SLAM. She was appointed as a panel of 3-member arbitrators for the first time in history of SEA Games during the 29th SEA Games Kuala Lumpur 2017. While Ms. Revathi is a practicing lawyer, alternative dispute resolution ADR practitioner and academician. She is the founder of a boutique law firm Messrs. Revathi and Partners, which handle all areas of law in general. She has been practicing law for the past 13 years and have also served as a legal advisor for one of the prestigious GLC company in Malaysia. She is actively involved in court mediation and is currently working with a well-known law book publisher in authoring a law book on family law in Malaysia, in which mediation in family dispute is one of the focuses in the said book. We are certain that their experiences and wisdoms will bring an eye-opening experience to us on how mediation works in real life. So, Ms. Samrith, by reading your profile, I'm sure you are very experienced in construction-related disputes. May I know in your experiences, what are the common disputes that arise in the construction industry?
Hi, thank you very much for your kind introduction and to invite us on this platform. With regards to your question, what are the common disputes that arise in construction industry? There's so many disputes that can arise in our construction disputes in the construction industry. The general one, the most common one would be the payment issues, performance issues, defect issues, poor workmanship, extension of time issues, variation orders where parties may have or may have not given instructions to vary certain part of the contract or the work, prolongation claims, whether certificate of non-completion is validly issued, rectification work, insurance, performance bond, delay, liquidated damages, loss and expense. The list can go on. So there are lots and lots of numbers of issues that can crop up in construction industry.
Thank you, Ms. Samrith. So, Ms. Revathi, in your opinion, what do you think is the advantage of mediation to resolve the disputes, particularly in the construction industry, in comparison to other alternative dispute resolution mechanisms like adjudication or arbitration?
Well, as we all of us know, mediation itself very voluntary and friendly proceedings. So if we look at what are the advantages, the most important thing parties normally goes for mediation to save the time basically, especially in construction matter. Because if you see in construction matter, there's many layers of profession involved. For example, the owner, the main contractor, the subcontractor, the consultant, the architect, the engineer, consultant engineer. So those are people who we call as experts. Let's say if there's a dispute in construction matter and we want to litigate the matter, it will take years for us to call all the profession and the witnesses, especially the expert witnesses, to put on stand and to put a submission, to reply the submission, to argue it in the court, and it will take time. So when we talk about mediation in construction, basically we can gather all the dispute in 1 or 2 days of mediation and to comprise the issues of the facts to settle it in one round of mediation to save time. For example, if in a litigating and construction matter may take 2 or 3 years, and mediation may just take us like 3 to 4 months to settle it in one round. And when you settle in a mediation, that means you get your money fast. So that's one of the advantage. Besides that, the relationship itself. You see, in construction, we will be meeting the same people again and again in that same profession. So if you go and litigate it, the relationship will become sour normally. So when you come to mediation itself, we call it as a settlement. So when you manage to settle it with the amicable way, we can continue to have that a very good relationship between the architect and between the consultant, the owners, and the contractors. And beside that, the cost also another issue. For construction matter, beside the legal fees, the claimant or the plaintiff normally need to pay the witnesses, or especially the expert witnesses, to bring them in court, to put them on stand. So in mediation, you can avoid those costs actually and expenses. Thank you.
Thank you very much for the very detailed explanation. So as both of you are aware, we have, in our previous episode, we have our negotiation role play. And oftentimes people could not differentiate the differences between negotiation and mediation, as they seem to be quite similar. Perhaps Ms. Samrith, do you mind to explain further on the differences between negotiation and mediation?
Sure. Well, negotiation is basically, it means getting what you want from the other party. So it's actually a discussion between parties trying to resolve an issue in an amicable manner. It goes back and forth between the parties. So it's, a back and forth communication between the parties, usually trying to avoid arguments there. So a lot of time, parties are compromising with each other to come up with an acceptable outcome. So negotiation actually involves some give and take, which means that one party will always come out on top of the negotiation. In negotiation, again, parties themselves agree to reach a settlement without the involvement of a neutral party. They don't need a third party to come and help them to negotiate. Parties themselves are coming on board to negotiate with each other. So it is actually akin to a bargaining process where parties, each knowing their interests and rights, are willing now to come together to discuss the differences and compromise with each other in order to reach a mutually acceptable solution. Now, the difference between negotiation and mediation is the value of a mediation as opposed to a negotiation is that the mediation involves a discussion facilitated by neutral third party, like I mentioned earlier. In this way, both the parties can state their position as well as hear and better understand the position of the other party. The mediator will help each party to do reality testing, test their position, whether it, whatever they are now coming out with, whether can it stand by itself, can the decision that they're coming up, like for example, if you say that, they agree to a payment of 500,000, whether that money, whether that person can pay you that money or not at the end of the day. So they do a reality test on positions that or the solutions that have come out with. And they also see the other party's point of view. They get the parties to do, the mediator will try to put the other party in his opponent's shoes. For example, by saying that if you were in his shoes, would you have done anything, different? So you make the person think, and you make the person realize that, okay, maybe if I was in the other person's shoe, I would have reacted the same way. And as well as to assist, a mediator also assists in generating options and looking into a range of possible outcomes, options which hopefully can conclude into a settlement agreement. So in mediation, the goal is actually for the parties to strive towards a solution that is mutually acceptable by both parties. Whereas negotiation, on the other hand, involves trading or bargaining to achieve a settlement. So these offers are usually speedily rejected. When you go into a negotiation, usually when you're not happy with the other party, you're just going to reject and you can walk away, not trying to resolve. Whereas if a third party is involved, a mediator is involved, he can try to calm the parties down and try, to get parties to talk to each other or try to resolve their issues. So in short, mediation, whether formal or informal, can often help solve conflicts that have gone beyond the negotiation stage. That's my take.
All right, thank Thank you. So although they are similar, but they are quite much different.
Yes,
sorry. So moving on to our next question, perhaps Ms. Revathi could explain further on how mediation works normally, like the setting of the mediation or how they choose the mediator, etc.
Yeah, mediation itself, how it works, when we say how it works, normally the most important thing is both parties, for example, the claimant and the respondent, both need to actually agree to actually mediate the matter. There's no point the claimant wants to mediate or the respondent wants to mediate, or the claimant is very adamant, I want to litigate the matter. So the first rule is both parties must agree to mediate. And thereafter, once parties has agreed to mediate, then they can actually approach a mediation center, for example, Malaysian Mediation Centre, recognized by the Bar Council, or AIAC, Asian International Arbitration Centre, or any other mediation center to appoint a mediator. That's one. So once that comes to a conclusion, a mediator is appointed. Normally what the mediator will do, the mediator will call the parties to have a pre-mediation session. So during that pre-mediation session, that will be like a kind of introduction session between the parties and the mediator. So the mediator normally will introduce who is he or she, what she's going to do during the mediation session, and she or he might require a brief facts from each party on their version or justification for that facts of the case. Then a mediation date, one date or 2 dates will be set, fixed, and the parties will be asked to attend the mediation date. So at the very first thing on the mediation date, basically, the mediator will actually give an undertake that this mediation will be conducted with fairly and honestly. So to make sure the mediation is success. That's one. Number two, if the parties, especially if the parties involve a company or organizations or a body, then the mediator will make sure that particular individual or representative who attended the mediation on that day has the mandate to make a decision. Because the purpose of the mediation to make a decision there itself. Because if you leave that particular session and for the parties to come back again for the mediation, then the mind will be disturbed. Then influence can be, came into the picture. If someone else influenced, the mediation cannot be success. So we want to make sure that those who attend the mediation has the mandate to make a decision on that particular date. That's one. Number two, on that date, what will happen? First of all, the mediator will have a private session with the parties separately. That's one. So during that session, the mediator will ask the facts of the parties on their version, because normally the claimant will have one version, the respondent will have one version. So the mediator will listen to their version, and what will the mediator do is the mediator will compromise or compress the issues as simple as can, so that to settle the matter easily between the parties. So once the issue is settled or set up on 1 or 2 issues for that particular claim or case, then the mediator will have a second session between both of them. So during that session, what the mediator will do, the mediator will suggest how to settle this matter. For example, if the issues is only on the payment, on construction matter, the payment issues, then the liability issue need to be sorted out first. What are the liabilities? What are the justification? So once it's confirmed, both parties agree, for example, okay, both parties agree under 50,000 is the payment to be made by the owner to the contractor, for example. Then the next question is mode of payment, how the payment to be made to the contractor, in what term the payment to be made. Is it a lump sum payment? Is it a monthly installment? What is the mode of the payment? So once this both issues has been settled, parties has agreed, then the parties will ask to actually sign a settlement agreement between the mediator. So the parties can rely on that particular settlement agreement in order to settle the 120,000 pending payment in the mediation. That's called a successful mediation, basically. That's about it on the how mediation works. Yeah.
I see. Okay. Yeah. As both of you are very experienced in this mediation field, is there any bizarre situation that both of you have encountered in your experiences during the mediation process, and how did you handle this situation? Perhaps we could start with Ms. Samrith.
Okay. Thank you for that interesting question. To me, for me actually, the most difficult mediations are those actually involving family disputes. Besides, of course, in construction, it's altogether different because it's just parties who are, sometimes at each other's throat. So due to very tense situation, height situation, they will not want to see each other. So I have parties actually screaming at each other in my office. I have parties who refuse to look at each other when they come in the same room. Some of them don't even want to come in the same room. There will be parties that will walk away, and I have parties that while having a mediation proceeding are just so angry that they just walk out and don't even come back. So, the important thing is for the mediator to handle the situation. So you give them space, you give them time out. And every time when you're engaging with them and you think that, it's heading to a blow up, you then break down, tell them to take a break, and then you go into a private caucus. A private caucus where I think Revathi does not explain is that way you just go, the mediator see each of the party separately in a room, and you can open up as much as you want in that private session where the mediator will try to calm the parties down. So that is a good technique to have. And for every step that they make, it is good for the mediator to remind the parties that you have made progress. Thank you for coming, and there is progress. Let's move on, kind of thing. And if they are agitated or if they just don't want to, cooperate, then you remind them, the purpose and the reason they came to mediate. Always commend them that they have done well in the sessions that leading up to their disagreement now. Even though how small the progression is, always give them that assurance that it's moving on well. So a good mediator will also try to move them away from their stand that they are right to looking at each other's point of view and trying to tell them to manage to resolve their disputes. Maybe Ms. Revathi has more to add.
Okay, I do agree. Actually, I totally agree with Ms. Samrith. The most difficult mediation to handle is the family dispute mediation, because normally if construction matter or any other civil cases, it's ringgit and cents, more to monetary claim. Then there's no issue. If parties cannot settle, okay, never mind, I'll go back to litigation, I'll litigate the matter. But family matter is not like that. You see, we as a mediator also, we do not want the matter to be litigated simply because we don't want the issues or dispute between family, which is supposed to be in a four corner of the wall, comes to the court in an open court and litigate the matter. And especially, I personally feel a matter which involve a child custody must be mediated. It's not an option. I always feel that it must be mediated. It should not go to the open court because the emotion involved, and it does not involve only a husband and wife, but there's another soul there, which is a child who can be less than 7 years old, who doesn't know what's going on between the parents. So the busy situation which I have gone through, basically, there's one mediation when this child custody matter, when what happened, the parents started pulling the child, one to the right and one to the left, and we are like, what's going on? So in this kind of situation, a mediator role is very, very crucial. The mediator must be able to control the situation, must give a stern instruction or direction to the husband or the wife to behave in the mediation. So what's important is the purpose of the mediation must be highlighted to the father and the mother before the mediation starts. The purpose is we want to settle. if you come with that intention or with the mentality that, no, I will try, I'll see whether I can settle or not. If cannot settle, it's okay, I'll go for litigation. It's not that way. In family dispute, when you come for the mediation, the intention must be that I need to settle for the sake of my child. So when the child is in the mediation, the parents need to behave in a manner where it does not affect the child's mentally or physically or in depression. The child can go into depression very fast when seeing the parents as such. So in that sense, the mediator need to make a very, very serious role in controlling the parents to make sure the purpose of the mediation, and we need to settle for the sake of the children, basically. That's my view on this.
Thank you so much for sharing such an interesting story. And we can understand that when there is more emotional related disputes, mediation is definitely a better way to settle disputes.
Yeah.
However, I'm also aware that there are such things as court mediation. Is there any differences between a court mediation and the normal mediation? Perhaps Ms. Samrith could address this question.
Court mediation is actually called court annex mediation here, and where the mediation services are provided by the court as part and parcel of the same judiciary system. So the court will actually send down the matter to another judge or the registrar to mediate the dispute, and upon successful mediation, it is concluded with a settlement agreement, then this is recorded as a consent judgment before the first judge. But however, if the mediation is not successful, then parties then just proceed to litigate the matter before the first judge in court. In the event the parties manage to resolve some issues, but not all, you can still enter into a settlement agreement, and that part of the settlement, you can record it, and then you go ahead and litigate the balance of the issues. So parties usually do not have to in court annex mediation, parties do not have a choice, but are obliged to go for mediation when the judge or the court sort of suggests to them. Whereas a normal mediation, it is entirely up to you. Whether both the parties have to agree, like Ms. Revathi was saying just now, it is important. The first starting point is the parties are willing to mediate. So if parties are willing to mediate, since it's called a voluntary process, then, so that's the difference between court annex mediation and a normal mediation. Ms. Revathi, you have anything to add?
That is basically the difference between the court mediation and also normal mediation. I just wanted to add one more thing, just to enlighten a layperson on this mediation process. Basically, the court mediation, normal mediation, when the parties agree to mediate, we will directly go for the normal mediation. Okay, we'll approach the mediation center. But if in a court mediation, normally what will happen, the court will ask us to close the pleading first in order for us to proceed for the mediation, to take a form in the mediation center in the court. Because basically, you see, if a current position, most of the court in Malaysia, they have their separate mediation center or a room actually. If in Shah Alam, there is specifically, there's one wing is actually allocated for mediation center, so parties can mediate before goes to the court. So normally why we need the pleading to be closed, so that the court or the mediator itself can know what is the claim all about, what is the defendant's defense, and what is the reply, or if there's a counterclaim. So basically, the claim and the defense will be there. So the mediator will know what is the justification of the plaintiff for the claim and justification for the defendants for defending the matter. So that will ease the process of the mediation. So if the mediation can settle, what the mediator in court normally will do, they will direct the parties directly go to the trial judge, and you withdraw the claim or you record a consent judgment immediately to dispose the matter on the spot, basically.
Yeah. And if I may add, a normal mediation, the role of the mediator is to facilitate, whereas in a court annex mediation, the role of the mediation actually is to evaluate. So they are actually an evaluative mediation type of setting. That means that the judge who is mediating will look into all the pleadings, and he will try to see what is the right solution to the problem or the dispute.
Correct.
I see. Thank you very much. So is there any factors that needs to be taken in account to have a success settlement through mediation, Ms. Revathi?
Like what I said earlier, there's only one mantra to make sure this mediation settle is the parties, the attitude and the mindset of the parties who are attending the mediation itself. When you come for the mediation, you must come with that mindset, with the open mind to go for mediation, to settle the matter amicably without any hassle. I do not want to show my ego to my opponent. Basically, we don't want to waste our time. What we want, for example, if your claim is about pending outstanding payment of 150,000 for the work done, so we know that, okay, I need to settle the matter for 150,000. That's all. You don't need to say that, for example, when we talk about mediation, it's like one party going up a little bit, another party coming down a little bit. So if you want 150,000, if the other party say, I have some financial difficulties, but I can settle it with 125,000 as a full and final settlement in one payment, mediator, actually, we normally will suggest, why not you take it? Instead of, for 25,000, you have to wait another 1 more year to go all out to litigate the matter. So that's how we normally will suggest to the parties to settle it. Or for example, if the issue is about a property, so your plaintiff is claiming for the total share of the property. If the defendant suggesting that you give me your house share of the property, but I willing to pay the money value for that market value of the house share, then we mediator normally will advise the claimant or the respondent, since you wanted the share, but at the same time, the other side willing to give you the money, the value for it, why not you consider of taking it, the amount, instead of waiting for another 1 more year to litigate the matter. And in litigating the matter, there's no such thing, a confirmation that the claimant will win, the respondent will win. It's again depends on your evidence, your documents, your witness testimony on that day. So all that very, very subjective. And you cannot read the judge mind, how the judge is looking at it. So if you can settle the matter through mediation, you can settle with good relationship and walk off from the mediation room actually on that particular day.
So there is actually no win or lose in mediation.
Exactly.
Yeah, that's what they always say, that mediation is a win-win. You have a win-win outcome instead of a win-lose outcome.
Thank you so much. So would you mind, would both of you mind to share your story and how did both of you started a career or ended up getting involved in mediation, and why mediation interests you? I'm sure this will help. This will be helpful for anyone who is interested in pursuing a career in this area. Perhaps Ms. Revathi could start. All right.
Okay. For me, basically, I started to explore all area of the law because during my chambering period, I was exposed to all area of the law. It's not that specifically on certain issues and all that. But when I started up my career, when I started up opening on my own in 2014, what happened? The family dispute has been increasing in our country especially. And I feel that there is no point in litigating family dispute to the end of the trial, because end of the day, it involves, like what I say, it's involved more to emotions. So the best thing to settle this family dispute is mediation. By way of mediation, we can actually get what are the mindset or what are the point that the petitioner and the respondent would like to put forward, simply because before they file the divorce petition, they might not wanted to communicate with their husband or wife because there's already dispute between them, or one of them might not wanted, they're no more interested to listen to their partner. So that's the reason they directly file the petition into the court. But in Malaysia, now currently, if you see, I have dealt with many family disputes. We normally, in family dispute, we will try to settle the matter in mediation first before we proceed for the trial. And very less family dispute matter will go for trial. So during that mediation, what the judge will ask is, or what a mediator will ask normally, will ask, what do you want in this family dispute? You want a maintenance issue, or you want a matrimonial home issues, or child custody issues? Let's see how to settle it. For example, if the child custody, if both father and mother both wanted a custody, then the mediator has a role to impress upon the parents or the mother and father what is the law under, for example, under Law Reform Marriage Act. Custody of the child below 7 years normally goes to the mother, except in very, very exceptional situation. Okay, presumption rebuttal. So we'll explain to the father. So in that kind of situation, the father itself will understand, oh, this is the position of the law. Even if I go for trial, if I cannot show any rebuttal presumption, then the custody will go to the mother. Then no point I'm arguing on the custody. Then he will understand that, okay, maybe he can have the visitation rights, or he can have overnight access rights. So on that point, we can actually settle that custody matter. And for example, maintenance. If the wife asking 1,500 maintenance, the husband say, I only can pay 500. The mediator has a role to inform the wife, actually, your husband actually earning only 3,000 ringgit per month. And he need his portion of money a little bit to spend for himself, his commitment. So when explaining those kind of things, parties normally will understand. So that's where I find mediation is very, very helpful, especially in family dispute matter. Maybe Ms. Samrith can add on that based on her experience in this field, actually.
I just enjoy doing mediation. I first stumbled upon it when I was doing my master's in UN in 2008. One of the subjects was AIADR, and we had such a good lecturer, Ms. Revathi. I'm sure everybody will know that in the mediation field. I think the way she taught and the way she presented the subject to us, it just was like an eye-opener to a different field altogether. And then I went on to attended the Bar Council's mediation training, where again, my favorite lecturer, Ms. Kuna, was there. And since then, there was no turning back, simply because it is such a satisfying or gratifying experience when you can assist or can facilitate parties mediating their disputes, and then when you end up with coming up with their own settlement agreement. It is such a wonderful feeling when you see parties shaking hands at the end of the session and thanking the mediator for helping them. So it's such a good feeling that you have at the end of the day, that you are not coming back from court all fussed and angry with your opponents, angry with how your witness answered, or the other opponent was treating you in court. It is actually a very nice feeling at the end of the day, and I rather mediate than litigate any time of the day.
There is not only one way in a legal career, there's only another way, like ADR and mediation as well, for anyone who's pursuing in this career.
That's right.
So, following up to my next question, I think both of you are aware that AIADR have our own AIADR mediation rules. May I know what do both of you think of AIADR mediation rules? Perhaps we could start with Ms. Samrith this time.
Yeah. I think the mediation rules are very comprehensive. It's quite easy to use, and it's in line with most of the ADR institutions. I don't think anybody will have problems using it. In fact, whoever chooses AIADR as their appointing authority, I would encourage anybody to be using these rules. It's just you can't run away, from. Most of the institutions have similar rules, and I think AIADR mediation rules is in line with most of the other institutions as well. Ms. Revathi?
Yeah, I do agree with Ms. Samrith. Basically, AIDR rules is actually quite comprehensive, because the most important thing in the mediation process is appointment of mediator, the role of mediator. So as a lay person, they need to know what actually the mediator will do in a mediation before they actually proceed to actually engage into mediation to mediate their case. So if you see into this AIADR rules, actually, they have in section of appointment of mediator, role of mediator, and also confidential part of the mediation process. So if a lay person go through the rules itself, they will understand what is the role of the mode of the whole mediation before they pursue for mediation, actually.
Thank you. So what do both of you think that what role that AIADR could play in mediation settings?
Yeah. If we wish to discuss on the role of AIDR, now itself, I believe that AIDR is playing a very important role in mediation, actually, in mediating most of the dispute to enable parties to settle the matter amicably. And I personally feel that each case has its specific expression on it. For example, if a case involving technicality on the engineering consultant, then the matter should be assigned to the expert who knows about the technical version of the engineering position. Or for example, if it's a family dispute comes to the AIDR to mediate, then I think it must be appointed or it must be assigned to a solicitor or a person who actually very well versed with this family dispute matter. So it's not about choosing a mediator, but the most important thing is, so the mediator will know how to attack those issues easily and suggest the best solution or best suggestion to the parties for them to understand how to settle the matter. That is the main concern on the mediation, I believe. So I believe I personally feel that AIDR are playing that role and should continue that, basically.
Yeah. For me, I agree totally what Revathi is saying. Just to add on, it is good to also create awareness. A lot of people out there, a lot of especially in the construction line, they may not know mediation. So how mediation, if at all they have a prerequisite in the agreement, sometimes they just feel that no show, or they don't try to do anything about it, or they just pretend to go for mediation so that they can just get a certificate to say that they could not settle, to then proceed to the next mode of ADR. So it is, I think AIADR could play a role in creating awareness, maybe by road shows or encouraging parties to have a mediation clause in the agreement. And like what you all are doing, provide workshops, training, webinars, hopefully seminars soon. And a series like that is a good start as well to disseminate information about mediation.
Yeah.
Thank you. AIADR will continue to progress on this objective to create awareness not only in mediation as also in the other alternative dispute resolution. Thank you very much for the high comments on us. And thank you very much, Ms. Samrith and Ms. Revathi today for sharing your insights and contributed to this fruitful discussion. I'm sure that through your sharings that viewers will be able to better appreciate the advantages of mediation. That's all for our episode today. Thank you all for watching and stay tuned on Admin AIADR channel for our future episodes. Thank you and stay safe.
Thank you very much.
Thank you.